All right. I think this is starting already. So, yeah, okay. Where are they? Hello, 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 everybody. Happy Thursday. I'm back. Welcome. Hello, Knowledge 2323. Welcome to my weekly pop culture legal chat. Thank you. Hello, Tavy, 2AV. As you guys are coming in, please let me know where you are joining me from. If this is your first time ever seeing my face or hearing my voice, my name is Natalie Pierre-Lewis. I am the owner and operator of NPL Consulting LLC, a business formation firm. What that means is that I help you get your business paperwork together. Things like how to get an EIN number, how to file your articles of incorporation, if you need contracts, if you need to get a trademark, if you need to know how to hire employees, all that stuff. If you need to know how to structure, the basics of your money management, I help you. Hi, Miss Whitney. I help you with all of that. You may be asking yourself, why am I qualified to help you with all of those things? Well, I'm very glad you asked. I am qualified because I have been a licensed attorney for over a decade. I've started multiple businesses for myself and others. I've had many careers in the realms of law, education, entrepreneurship, hospitality, and administrative support. And most important, I am very passionate about making business and legal education as accessible to everyone as possible. If you would like to know where I am broadcasting from, I'm located in Hyattsville, Maryland. But I'm worldwide with this Instagram and live streaming YouTube thing. All right. Again, as you're coming in, thank you, Miss Whitney. As you're coming in, please let myself and other viewers know where you are joining us from. So before we get into the content today, if you don't know, every week I talk about celebrity stories. Hello, Candy Apple Red 260. Every week I talk about pop culture stories that are in the news, especially having to do with legal aspects like trademarking or contracts, and I break them down and we discuss them on here. Okay, so that is what this whole show is about. It's about taking legal concepts and applying them to pop culture, which I think is kind of fun. But before we get to that, I want to let you guys know a few things. First, if you are thinking about starting a business or on the verge of starting a business and you don't know where exactly to start, I want you guys to go to the link in my bio, linktree/NPL Consulting Firm, and download the Business Prep Toolkit. It is going to help you streamline your ideas, figure out what business idea you can start today, and give you the first steps to do so. Okay, and it's completely free. It was a joint venture between myself and Shara Gibson Consulting, a great business development person. As you can see, my dog Dallas is completely excited about the Business Prep Toolkit. He loves it. He thinks it's great and he thinks you should download it. So I would take Dallas's, endorsement because he's very discerning. We get it, Dallas. Next thing I want you guys to know about, I want you to put this date in your mind. March 20, 2019, March 20, 2019, March 20, 2019. Ladies and gentlemen, this is the date of my intellectual property webinar. If you have ever thought that you wanted a trademark, a patent, or a copyright, or if you don't know the difference between these three, guys, I am doing a webinar in March that is going to teach you about all three of these things and how to apply for them. And I am going to teach them to you for the low. Now, the tickets are not on sale yet, but I want you guys to keep that date in your mind, because when tickets go on sale, I want you to hop on the early bird. Business Launch Boot Camp, some people got the early bird, but some people didn't. They had to pay full price. Why pay full price if you don't have to? So March 20, 2019, keep that date in your mind and keep an eye out for when tickets go on sale. Early bird tickets are going to be only $11. $11 to learn how to protect your business ideas. I don't think that's a bad investment. If for some reason you don't catch the early bird, regular tickets are going to be $21. And if you are one of those last minute people, the last minute tickets are going to be $25, okay? Those tickets are not released yet, but I want you to keep the date, March 20, 2019, in your head. That is my intellectual property workshop. And the last thing I want you guys to keep in mind is if you have ever wanted to have an attorney on standby, like somebody just to pick their brain to ask them, hey, is this okay? Can you look this over for me? Ladies and gentlemen, I have the perfect thing for you. I have a private Facebook group called MPL Nuggets. And for $9 a month, you can have an attorney on standby. You can have me on standby. Meaning you get access to all of my digital products, meaning all my ebooks, videos, anything that I find to be of useful to entrepreneurs. There will be monthly chats where I will do different topics on business formation, and we can talk in the group together as well. You'll get to network with other business owners, and you just get access to me. You get to ask me between 3 and 10 questions a week. That depends on membership, but basic level membership for $9 a month, you get to ask me 3 questions a week. Okay. All right. So that is all the housekeeping that we have today. And we are going to get to our pop culture legal chat. All right. So I told you guys that if you got the email from me, or if you saw my stories today, one of the main stories, 2 of the main stories that I'm talking about today are, hold on one second, guys. My dog is trying to destroy something. Give me that. Sorry. One of the main 2 of the main stories that I said I was talking about were Rihanna and Drake, and those are coming in the live stream. You just gotta hold on because we got some stories in between. I haven't been on in a while, so we gotta catch up on some stuff. All right. So the first story that we are talking about is Kylie Jenner is trying to get a trademark infringement lawsuit thrown out. Now, if anybody knows me, they know that I am not a fan of the Kardashians. I think they steal. And this case is exactly why. So, Kylie Jenner is being sued for copying another makeup line. Hi, Latrice, love life. How are you? Now, there is a makeup line called Sheree Cosmetics. Okay. And they are suing Kylie for essentially for copying a line of eyeshadow that they released in October of 2017 called Born to Sparkle. Kylie released a line of her own called Born to Sparkle on August 28th, 2018. Now, the problem with Sheree Cosmetics, there are a few. One, Sheree Cosmetics did not file a trademark for the Born to Sparkle eyeshadow line until August 24th, which was 24 days. Hello, Cynthia Opong, which was 24 days after Kylie released her eyeshadow palette. Now, yes, they were selling these palettes, but they didn't have the trademark for it. It doesn't mean that they're going to lose, but it's kind of weird that you waited until, well, not weird, but you know, nobody thinks that people are going to steal their things. But okay, but that is besides the point. That Kylie's being sued for what the Kardashians do, stealing. But the important part of this case is that her attorneys are trying to get this case thrown out based on what is called venue, or where the case is being tried. So Sheree Cosmetics, they filed suit in New York, right? Dallas, shh. However, Sheree Cosmetics is actually based Sheree Cosmetics is a Missouri company that is based in Alabama, and Kylie, of course, is based in California. So the argument is none of us live in New York. Why did this person file in New York? Let's move the case to California. So that is what Kylie's lawyers are saying. They're saying that it's going to be too expensive for both sides to have to fly lawyers up to New York and, you know, take depositions and things like that. So they're saying, throw this out and make her file in California. All right. And I wanted you guys to hear about this case because if you ever have to file a case against somebody, be it business or personal wise, you need to think about where you are going to file. Okay, you can't just file in any state. You typically, if you have an agreement with a company, there is something in your contract that will say what state's laws govern your contract. And you have to be wary of that. You have to think about that, okay? So if you have a company and they say, well, if you have an issue with us and you sue us, we're going to be governed by the laws of Missouri, that means that you have to file in Missouri, okay? So venue is important when you're thinking about where you're going to file suit against someone, all right? So that is story number one. The next story I want to talk about, we have actually a couple of international cases today, and I think it's interesting because trademarks are important all over the world. You guys have heard me talk about Christian Louboutin going to different countries all around the world to try to trademark his signature red bottoms, and that he's had, success in some and has not had success in others. So worldwide trademarks are a thing, and, you can protect your mark worldwide. I don't know if you guys have ever heard of the Wagamama Noodle Company, but it is a UK, United Kingdom based noodle company, and they sued another company called Wakayama, which was another noodle company that was trying to come up. And Wagamama basically said that Wakayama was too similar in sound and the look that they had for their noodle company to Wagamama. And Wagamama won. And I think it's pretty obvious. Like I've heard of Wagamama for the last few years. I think I first heard about it in college. But I, as someone who is not necessarily the biggest noodle, discerning person, might mistake a Wakayama for a Wagamama, So good job for them. All right. Guys, if you have any questions about these cases, please drop them in the comments. I would love to interact with you or if something isn't clear. And before I start the third story, I want to introduce myself to those who came in. I'm Natalie Pierre-Lewis of NPL Consulting LLC, a business formation firm. I help get your business paperwork together. If you are interested in any of the things I do, go to linktree/NPL Consulting Firm, where you can find things like my business prep toolkit that will help the newer aspiring entrepreneur streamline their idea to make it a reality and a business. There you will also find links to my podcast, where I interview entrepreneurs in unique areas of industry. You will also find access to a lot of my free ebooks and everywhere that you can find me on the internet. If you are interested in essentially having me, an attorney, on standby for you, I invite you guys to join my private group, NPL Nuggets. It is just $9 a month, and you have an attorney like me on standby. Okay, so let's move on to our next story. Our next story has to do with the little guy beating the big guy. This is a story out of Ireland. So there is a chain in Ireland called Supermac, and they went toe-to-toe with the fast food giant McDonald's over use of the term Big Mac. So basically, Supermac, which is Super MAC, they, had certain items on their menu, including one that was called Big Mac. McDonald's sued them, saying that them using Mac anywhere on their menu infringed on McDonald's trademark on Big Mac, okay? The Big Mac sandwich, okay? Supermac said that there's no reason for them to sue them because they have a totally different logo, totally different decor, that under no circumstances would nobody mistake Supermac's food for McDonald's food, okay? What happened was McDonald's lost. not because their trademark was bad, but because the EU court said that the European Union court that tried this trademark case said that they had not used their Big Mac trademark in the last 5 years. The court said that Big Mac is a product and it's not the name of the company. So had they sued under McDonald's, that it was, going to interfere and be confused with McDonald's, the EU court said they might have had more standing. But nobody's going to mistake an entire restaurant for your sandwich. Dallas, get out. Okay? So that is the case of how the little guy beat the big guy. The Irish chain Supermac beat McDonald's concerning their Big Mac trademark. Okay? So good for them. The next case that we are talking about. Ooh, all right. So this is the one that I told y'all about. Rihanna is suing her dad for using his own name. Now, I'm going to explain why. So we all know Rihanna has, welcome to my co-host, Dallas. We all know that Rihanna has Fenty Beauty, right? Make really big brand. She's got Savage Fenty. The Fenty name is worth a lot of money, right? So Rihanna's dad started his own company, Fenty Entertainment, which is a production and talent agency, in 2017, okay? He launched it around the same time that Rihanna launched her beauty line, Fenty Beauty, okay? Not only that, he falsely represented himself as affiliated with Rihanna. He has never had the authority to act on her behalf. But basically what he did was he started a company, named it Fenty, and said, hey, I'm Rihanna's daddy, work with me, okay? So he also, aside from the entertainment company, tried to register the Fenty name for a line of resort hotels, okay? Doing this, under starting these companies, he negotiated unauthorized deals for her to perform 15 shows in Latin America for $15 million. You think Rihanna's going to perform 15 shows for $15 million, a million apiece? That is chump change for Rihanna, okay? So he negotiated unauthorized deals for her to perform 15 shows in Latin America for $15 million, 2 15-minute sets at an event called Calabash in the Staples Center and at the T-Mobile Arena for $400,000. These don't even sound like Rihanna numbers, okay? Now, the suit that Rihanna has against him is asking him to stop misrepresenting himself as a representative for Rihanna or her interests, because he is not. And they also want him to stop using the Fenty name for his businesses. I mean, while it is his name, she got her name from him. It stands to reason that anyone seeing the Fenty name is going to associate that Rihanna with Rihanna, on top of the fact that he started these companies around the time that Rihanna started her own companies. So anybody who does even just a little bit of background work, they may see that, oh, all of these companies were started around the same time. They must be related, right? So there's always that danger. It's really sad that it's happening from her father, but, them's the breaks sometimes. So that was the thing about the Rihanna case. The next case I want to talk to you about is how I'm aging myself when I talk about this, but how many of you guys know about grunge music from the 90s? If you don't, one of the founding bands of that movement was a band called Nirvana. If you have ever heard of Kurt Cobain, he was the lead singer of that group, and he took his own life very young. Despite that, the group, their fame, it lived on. Their music is well known. They are suing for copyright infringement against Marc Jacobs. Okay, they're saying that Marc Jacobs is using their famous smiley face without permission. Now, whoa. Hold on. Okay, guys, my Facebook just conked out. I gotta go back on. Give me 1 second, okay? So I'm going to show you a side-by-side picture of the Nirvana logo and the Marc Jacobs logo. And you tell me what you guys think, okay? Okay, so Facebook might... So, on this side right here, this was the Nirvana smiley face that they used on their albums, okay? Now, as you look closer, this is the Marc Jacobs smiley face. Instead of the X's, it has MJ, but it has that squiggly line with the tongue. And what Nirvana is saying is that, well, first of all, this symbol, this Marc Jacobs symbol, it's being used for their Redux grunge collection, right? So obviously grunge, Nirvana is one of the founding members very closely associated with grunge. Anybody who is a grunge fan is thinking about Nirvana. So if you're using this famous smiley face and you're calling your line Redux Grunge, it stands to reason that someone might think that you got permission from Nirvana to use this symbol, right? Nirvana is saying, no, that's not the case. They are saying, hey, girl, you're trying to associate yourself with Nirvana. We're the founders of grunge music. And you just don't have that permission. Marc Jacobs also used famous Nirvana song titles in their marketing materials, or album titles, I should say, like Smells Like Teen Spirit. Smells Like Teen Spirit and Come As You Are, okay? Nirvana's representatives are saying that they are diluting the value of Nirvana licenses because, you know, people are very attached to music that, you know, came around the time that, you know, they were coming up. It can be very personal. And for you to say that, you know, as a fashion label, you're using their symbol, people are going to think, oh, Nirvana's doing clothing now, okay? Nirvana's people are suing for money damages, and they want Marc Jacobs to stop selling the Redux line, and they want them to remove the images of the smiley face. So that is what they are suing for on their end, okay? So I'm going to keep an eye on that. And keep in mind, they are suing for copyright infringement. They're not suing for trademark infringement. Now, remember, whenever I've told you about copyrights and trademarks are used to protect your brand or logo in the marketplace when you're selling something. Copyrights are when you create a work of art and you want to control who can do stuff to it, who can make copies of it, okay? So they're suing under copyrights because this is their art that they created, all right? My Facebook is acting up, y'all. Okay. So, next, we talking about Champagne Poppy, y'all. But before we go into that, I want to reintroduce myself. I'm Natalie Pierre-Louis. I'm the owner and operator of NPL Consulting, LLC, a business formation firm. I get your business paperwork together, y'all. If you are thinking about starting a business or want to start a business, I want you to go to the link in my bio, Linktree/NPL Consulting Firm, Linktree/NPL Consulting Firm, Linktree/NPL Consulting Firm. Hey, Facebook, I'm sorry I cut out. I want you to go back to the link in my bio and, or go to the link in my bio and download the Business Prep Toolkit. It's going to help you get yourself together. As well, I want you guys to know that I have a private Facebook group where you can have, Facebook is not even live. I was talking to myself in the other screen. Hold on 1 second. Instagram. Oh, hi, welcome back, Facebook. I'm just reintroducing myself, Natalie Pierre-Louis, owner of NPL Consulting LLC, business formation firm. Go to Linktree/NPL Consulting Firm to see all the things I do. All right, next story we are talking about in our pop culture legal chat is Drake. Drake has partially lost a trademark battle in the 6 for the 6. Okay. So here's the story. Okay. Drake and his team tried to trademark the word 6, and the way it was spelled was the number 6IX, right? When they filed, they found out, and they tried to file this in August of 2015. When they filed, they found out that a DJ by the name of Michael DeCosmo had already filed a trademark for that same name in December of 2014. And they tried to block it, okay? Because they said that they had already been using 6 on merchandise. This DJ, Michael DeCosmo, said that he had been performing as DJ 6 in some form or fashion since since March of 2000, okay? He had flyers and all that stuff. So the court basically, DJ 6 or Michael DeCosmo wanted the entire trademark because he said he wanted to start coming out with his own brand of clothing. But the court in Toronto said that while he could have the trademark for his DJ name, he could not have it for merchandise. But yeah. So he could use it for his DJ name, but he couldn't use it for merchandise. And just to let you guys know, while we in America may not have known Toronto as the 6 until Drake, kind of brought it up, in Toronto, calling Toronto the 6 was a very common practice among underground rappers for a long time. So it was not invented by Drake. It's been called the 6 for a long time. So it was a matter of here who established it first in time. And in this case, the little guy kind of won. I mean, it's kind of half and half. Drake is still going to sell 6 merch. They're just not going to have the trademark on it. Okay. Next story is I want to talk to you guys about Wendys is being sued by a sauce company. All right. I have never noticed this, but apparently Wendys has some sauce that is called Sauceum. Okay. There is a company called JMO Sauce Company. They had a similar sauce or a similar line of sauces called Sauceum that they trademarked in 2015, and they sold it all over the country. Wendys started having ads for their own kind of Sauceum sauce in 2017. JMO, I should say, sent cease and desist letters to Wendys, but Wendy was like, what are you going to do about it? And kept promoting it anyway. So JMO is now suing for monetary damages, and they want Wendys to stop using the name. So I'm actually going to keep an eye on that because I want to see who wins in that case. That'll be interesting. Okay. Ooh, interesting. Another one. This is a case out of Hawaii. All right. I'm sure if you enjoy, if you imbibe, if you drink, you may have heard of Kahlua coffee liqueurs. That company is actually owned by the Swedish company Absolut. Okay. So Kahlua, Kahlua. Well, they are suing a small company in Hawaii that is owned by a gentleman called Owen O'Callahan. Owen O'Callahan has a company where he makes these things called Hawaiian Happy Cakes. And he was branching out into coffee, and he is coming out with a brand of coffee that is called Kaholo Coffee, Kaholo. Now, Kaholo in Hawaiian means swift or nimble. So Absolute heard about this, and they basically are suing this guy, saying that Kaholo is too close to Kahlua and that people would mistake his coffee for their coffee liquor. This business owner, he's saying that basically Absolute is trying to bully him through trademarks, and he's fighting it. He's like, it's not close. We're not doing the same thing. And he said, I'm gonna fight it out. So we're all gonna stay tuned. Ooh, what is that? We're all gonna stay tuned for that story to see who wins, David or Goliath. Okay. Two more stories. But before I start on them, y'all, I want y'all to keep this date in your mind, March 20, 2019. March 20, 2019. March 20, 2019. That is going to be my intellectual property workshop where you're going to learn all you need to know about patents, trademarks, and copyrights, whether you need them and if you need them, how to get them. Early bird tickets are going to go on sale for just $11. This is going to be a webinar, so you're going to be able to do it from the comfort of your own home. So no excuses, all right? And early bird, just $11. You're going to be able to learn all that stuff. So keep an eye out for those tickets. Now, as we go into our last two stories for today, yet another artist is suing Epic Games for stealing their dance. If you guys have heard of Block Boy JB and his shoot dance, he is at least the third artist in a line of people, including 2 Milli and Alfonso Ribeiro, to sue Epic Games for copyright infringement. Now, again, he is not suing for trademark infringement. He's suing for copyright infringement because he said that he created this dance, it's his, and he should be able to say, and it's distinctive to him, and he should be able to say who uses it. So again, like the other cases, I'm keeping an eye on it. I think that what Epic Games is eventually going to do is just stop using these dances. Thank God. Or just cut these people a check. Stop stealing. You guys have all the money. Like, what the heck? You know? Okay. So, yeah. So, Epic Games. And the last story that we are talking about today is Starbucks. Guys, Starbucks just won a huge trademark. Okay? So, everybody knows the iconic Starbucks logo. But they just won a trademark for a cup with just a green dot. So if someone was to, put this in some type of advertisement, just this would be enough to basically spark a trademark infringement suit, because Starbucks is saying that we're well known enough that when people draw a coffee cup with a lid and a green dot, they know that it's Starbucks. So that is really important because that is such a basic shape and a basic symbol that, I'd be interested to see how that pans out in the next few years with like TV shows and things like that. So those are the cases that we had this week. Thank you to people who submitted a story. Thank you. I invite you all to submit stories every week because, I can't catch all the stories myself. You can email it to me. You can DM to me wherever you find me. Just send them. As well, thank you to Facebook for putting up with the technical difficulties. As well, one last time, guys, go download my business prep toolkit and keep an eye out for my intellectual property workshop. It's being called Protect Your Biz 2019. Tickets go on sale soon, and they are just $11 for early bird tickets. So I don't want to hear that you can't afford it because it's only $11. And you're going to learn a lot of information. Plus, you're going to get copies of the 2 new ebooks that I'm creating, the one on patents and one on copyrights. It's going to be a whole intellectual property series to accompany my trademark ebooks, okay? So that is what I have for you guys today. Thank you for your time and attention. And I will talk to you guys later. Bye.